also a complicating factor. And fourth, of course, is the growth of human rights. Most of modern human rights as we know it emerges after 1945, particularly after the war of 1948, 49, and going on forward. So this conflict and this piece of real estate is caught in between these tectonic shifts in international law that are all occurring at the same time, which create a very complicated international legal landscape, which I think is, I guess my position as a commentator is to draw some of the nuances and how difficult, how it's not a very straightforward story. I did want to, last point before I open it up to questions. Because the legal landscape is so nuanced and so unclear, all sides to it are forced to draw upon legal concepts that don't really quite fit very well. So, for example, I personally feel that the application of the Fourth Geneva Convention to this particular piece of land is not an ideal fit. If you look at the background to the Fourth Geneva Convention, it was very much meant for a state-against-state conflict, such as occurred during World War II, and movements of populations based on it. That doesn't mean it couldn't be applied to this, but it's not a straightforward fit. To take the other point of view, however, in in your paper where you refer to the concept of terra nullius, I also don't think that's a particularly good fit. I mean, the historical applications of terra nullius are old. It's an old doctrine, and it typically applies to land that really had no valid claims to it. It's hard to think of applying terra nullius to a piece of land which has had perhaps more claims to it than any land in history over long periods of time, to think that that's the solution and that justifies a unilateral resolution to it. So those are my observations and criticisms, and I hope to leave at least a little bit of time for your questions. Thanks.
I apologize if we ran a little late, but for those students that have to go, thanks for coming. Anyone else? I know Professor Krauss can stay for a while. I'm not sure about Professor Dubinsky, but let's open it up to some questions. In the back, if you could speak loud, we don't have any wireless mics.
Can he respond first to the comments?
Well, I'm going to have is there something specific? Maybe?
So, I think we only have 5 questions.
Okay.
There's so much here. Very, very briefly. So as I understand your basic legal argument is that upon the demise of the Palestine mandate for Britain, the territory became res nullius. If that's correct...
I'm only talking about the territory that became res nullius was a territory over which no state had title. Right.
So I assume that if it's res nullius, then Jordan could have claimed title?
Yes, that's right. Jordan's title was vitiated by 2 things. It had acquired the land as a result of an illegal aggressive action.
How can it be an illegal aggressive action if it's res nullius? That means it's open to action.
No, it was attacking another state. It was attacking Israel. That was illegal aggression. And it was that illegal aggression that allowed it to occupy the West Bank. We're talking about the West Bank as the res nullius here. And that West Bank was occupied by Jordan as a result of, in fact, it's because of that only 2 nations recognize its sovereignty. So you need a couple of things. By the way, Professor Dubinsky is exactly right. If I'm talking about a primer, this is an exceedingly complicated, nuanced area of the law, but speaking very broadly, you need control on the ground, boots on the ground, and you need recognition. And Jordan had recognition by 2 countries in the world, one of which was self-serving, and that was Great Britain, because it had violated the mandate by granting rights to Jordan in the first place. The other was Pakistan. So Jordan has a very, very weak claim. In fact, and Jordan has not had boots on the ground since 1967. So it hasn't had boots on the ground at all, and it only ever had a very slight recognition by others. By the way, I didn't claim that Israel's I think I did say explicitly that Israel's claim over this res nullius is not invincible. Indeed, Israel has weakened its own claim over it. If it wanted to make such a claim, it's never made such a claim. And today, if a government tried to make such a claim, it would be weakened by certain Israeli actions. Israel has continued to decline to apply Israeli law domestically to non-Jewish populations inside Judea and Samaria, for
So really the
example.
clock starts after the British leave, right? So all historical claims prior to that have no relevance to the West Bank because it becomes res nullius right at that point.
Right, and so the basic thrust of the basic thrust of that part of my argument was encapsulated by this quote by Judge Schwiebel, who said that, you know, as between a state, I was thinking of the two prime candidates being Jordan and Israel, as between a state that occupied in the past through illegal aggression and a state that now occupies because of a defensive war, the state that occupies because of the defensive war has a stronger claim in international law. That was the claim, not that it's an invincible claim. In fact, Israel has made it more invincible, more defective, because it's weakened its own claim voluntarily. I'm sure, I understand.
Just say one minute. I should also say I don't view all Palestinian claims as having to be derivative of Jordan. So the black and white picture, either it's Jordanian or it's Israeli, and if you can't get your claim through Jordan, I don't think that's right, because self-determination plays a role. There's the example of Kosovo and so forth. So I think it's more nuanced than that.
Side.
Yes, sir.
Yeah, either of you.
Can you speak up, sir?
My question to you is, with the recent events in Egypt, do either of you consider that this is the first phase of a war